The DOJ drops its gun rights restoration plan and ends the legal fight over the pistol brace ban. That and more on the news update.
No, the devil's got no hold on me.
All right, welcome, ladies and gentlemen, to another episode of the news update here at the Reload. This week, as you could tell immediately from this intro, I am standing in as our host, as Jake Fogelman, a contributing writer, is out getting married and then going on his honeymoon. And to help me do the news update this week and next week, which we will be doing both days on Thursdays, because of some of the restrictions here related to Ben Owen, our National Journalism Center intern and the reporter for the Reload. On Fridays they do their National Journalism Center meetings where they do things like our range day, which we'll get into later on in the show. But welcome, Ben, to the news update. How are you doing? It's your first time on a podcast, right? Or news podcast, at least.
Yeah, thanks for having me on. I'm doing great. I've really enjoyed getting to write for the Reload. I'm excited to participate in this podcast.
Yeah. No, it's been great having you so far. I think you've done a lot of really good stories. We're going to talk about a couple of them here today. But just give people just a little bit of background about who you are and how you came to be a Reload intern and what your role at the National Journalism Center. Just to tell people a little bit more about yourself.
Yeah, so I am 19 years old. I attend Liberty University and I'm studying law and policy right now. And my school has an internship program where we can live in DC and get placed at internships around the area. And one of them that I applied for was National Journalism Center through Young America's Foundation. And through them, I got placed here with the Reload. So I've been able to write for the Reload Monday through Thursdays every week, I started in late May. And on Fridays, I've been able to attend Young America's Foundation's lectures at their office to learn more about journalism and just improve my skills in this area.
Yeah, and I would say that you've made a lot of progress in the time you've been here. It's not easy necessarily to just adapt to news writing because it's a sort of different style from all kinds of other writing that you see out there. And I know that you also are interested in maybe going to law school and you're very interested in law. And so we've got you doing a lot of legal stories as well here. So, I think you've done a good job of adapting to that. And let's get into some of those stories. We'll talk a little bit more about your experience at NJC and the Reload at the end of the show. But let's start off here with something in the legal realm, right? Which is the DOJ's new proposed rule for reigniting the federal rights restoration process for those who have been convicted of certain crimes, certain felonies, or misdemeanors, and also have had their gun rights stripped away by federal law. DOJ has been promising to release details on how they're going to restart this program, which had existed, which is authorized under the law, under the Brady Act. There's a way to, or under the Gun Control Act, there's a way to get your rights back after you've been put in a prohibited persons category through conviction or adjudication for mental illness or something along those lines. And that process had happened up until the 1990s when there was controversy around it and Congress passed a rider for their budget, which is actually still in the new Senate version of the appropriations bill right now, but they blocked funding for this process at the ATF. And so the way the administration has gotten around that so far is to say that they're the Attorney General is rescinding that authority, taking it to the Department of Justice, taking it away from the ATF. And then earlier this year, there was some controversy around the first batch of these people to receive rights restoration because Mel Gibson, the actor, and a supporter of the president, was one of the first 10 to get his rights restored despite a domestic violence. He pled guilty to domestic violence incident. It was a misdemeanor, but misdemeanor domestic violence makes you a prohibited person under federal law. And so, it was just sort of an ad hoc process at first. There was no real explanation for why the people who got their rights restored actually were picked. And in fact, there was a pardon attorney who was fired over this disagreement over Gibson getting his rights back. But anyway, it's been several months since that happened. And now the DOJ has released their actual detailed rule for how they're going to do this process. And, it provides, I think, quite a thorough update on what's going on here, and gives you some real insight into what they're actually going to do and who will be really eligible for rights restoration. And Jake actually wrote a whole analysis piece that looked into the details of this rule and kind of broke down how it's going to play out, and had a great piece for members over on the Reload where he explained the ins and outs of this new rule, which is actually pretty interesting in that I think it's fairly reserved, and a lot of the people who are going to be eligible for this process, like it may not cause that much controversy, right? There's maybe one part I think that could, but for the most part, it's basically not eligible. There's a whole list of people that they say are presumptively ineligible for relief, and that's pretty much anyone who committed some sort of violent act, murder, rape, people who are unlawful users of controlled substances, fugitives from justice, those subject to domestic violence restraining orders, are in there. Illegal immigrants are included as presumptively denied. And, you have all kinds of felony crimes, sex crimes, what the DOJ says are crimes, quote, closely associated with dangerousness, such as threatening or stalking offenses. So, a lot of the more egregious criminal acts will not be things that you can have your gun rights restored from. So they claim that the rule would only allow rights restoration for people who've committed, quote, less serious crimes or those indicative of violence. So, they're starting off from this point where they're saying, to be clear, they do go out of their way to talk about how these aren't going to be categorical. So in theory, people who have those sorts of convictions could get their rights restored. It's just that they will start off with a presumption that they will be denied, right? And then so for the people who are not in those categories, they're much more likely to get their rights restored. But this rule basically says the Attorney General can make a determination based on the facts of the case, right? Essentially, like they can go outside of what's presumptively denied and presumptively not, or not presumptively denied, to restore anyone's rights, essentially, which could lead to controversy if they actually, depending on how it plays out in practice, right? Like the Mel Gibson thing. Obviously, that was viewed as controversial, both because of his actual criminal history of being one that involves domestic violence, but then also the story that he got pardoned because of his connections to the president, right? So in theory, this could, because they're talking about how they're rejecting a narrow categorical approach, like it's not supposed to be totally automated, and they're saying they could do this rights restoration process for kind of anyone who the AG determines should have their rights restored. Now, it seems like, honestly, reading through the rule and Jake's description of it, it feels more like they're just kind of saying it's not going to be a narrow categorical approach, but the rule kind of lays out a process where if you meet certain criteria, you probably get your rights restored. If you don't meet that criteria, you probably won't. But they give you a number of rules essentially for who would actually qualify. So, as Jake notes here, for some crimes like drug distribution or misdemeanor domestic violence, which does qualify as not presumptively denied here, which that's I think the one part that could become controversial. But they say for those crimes, drug dealing or misdemeanor domestic violence that quote bear a more direct relationship to violence, the department will consider applicants without a presumption of denial only after 10 years. So for some crimes, they're saying, there's a presumption of denial. Doesn't matter how long it's been or what the person's record is. Outside of the AG can make an exception in extraordinary circumstances is how it's supposed to go. But for domestic violence or drug dealing or some of these crimes that are, as they say, bear a more direct relationship to violence, I suppose in the case of domestic violence, it's a literal direct relationship because it's a domestic violence conviction, but even if it is a misdemeanor one and not a felony one, but they're going to have to wait 10 years before that presumption goes away. And it's the same for some other crimes. There was like a 5-year waiting period as well. But overall, they're basically targeting nonviolent felons with this for the most part. Nonviolent felons, and then there's the exception being domestic violence misdemeanors and perhaps drug dealing. Even if it was a nonviolent felony conviction for drug dealing, they still want to put a 10-year wait time on that without reoffending. They talk a lot about these time frames too, like most people who reoffend within the first couple of years. So that's why they put some time gates on this process for certain people. But mainly they're targeting nonviolent felons with less controversial convictions, for the actual bulk of this potential rights restoration effort. So I don't know. It seems like a pretty seriously thought out attempt to flesh out this rule. We weren't sure when that was going to happen or if it was going to happen, but it appears it has happened. And, this will go to, I believe it's already in the comment period. So we'll see what kind of reactions, I guess, people have to it and whether they end up changing any of it. Like I said, I think the domestic violence misdemeanor aspect may get pushback. But otherwise, it seems like something that is not going to generate a lot of controversy, perhaps. I mean, I think Drew Stevenson, who's a more liberal professor of law and critic of like the Bruin decision and believes in more restrictive gun policy. I saw his reaction was fairly positive to this for the most part, especially because there's a whole section that talks about what you have to do to get the rights restoration, which is you have to submit all of your criminal records and records after being released from prison to show that you haven't reoffended. You have to send character references. You have to have 3 character references, which includes even like that you don't have a drinking problem, for instance. And you have to show essentially that you've finished your sentence, come out of prison and reintegrated into society without issue is kind of what they're looking for. That's the process, right? I mean, that you read the piece as well, Ben. What did you make of the process here? Do you see any issues perhaps with with the process or something that the administration might run into as far as opposition goes?
It seems like the way that they've laid it out, they've narrowly tailored it a little bit towards the less controversial people. So I doubt that they'll run into any problems with it. I think one of the important things to recognize with this plan is the historical context, like why this is being implemented. So in the circuit courts, especially since Bruin, there's been a real circuit split on what sorts of felonies are legal constitutional justifications to have your Second Amendment rights removed. And some circuits have said that certain historical examples do justify for all felony convictions. And some have said, no, it only really counts towards more dangerous felonies. And that really up to this point has been the only way, the courts have been the only way to get your rights back since the rights restoration program hasn't existed in 30 years. Right. And so the DOJ is going to be able to help those, especially in certain circuits. I believe it was the Second Circuit that said all felony convictions, no matter how dangerous, even if it's financial, whatever, they said that you could have your rights taken away because of that. And now the DOJ is coming in and saying, hey, here's a process where we can give you your rights back.
Yeah, and on the other side of that coin as well, you've seen some courts like the Third Circuit rule that, like the Range case, for instance, we've talked a lot about on this show over the years here, that there are circumstances where this is actually unconstitutional. These lifelong prohibitions on gun ownership don't comport with the historical tradition. The Supreme Court hasn't weighed in on this, except to say in Rahimi that the domestic violence domestic violence restraining order prohibition is constitutional, but they go out of their way in Rahimi to take a very narrow view of what they're declaring constitutional. So they're not saying all of the prohibitions, all of the lifetime prohibitions are constitutional. They're saying the domestic violence restraining order one is constitutional in part because it's only temporary, at least in theory. If the restraining order goes away, then the restriction no longer applies. And so there could be an implication there. You can read an implication from the Supreme Court that maybe the lifetime bans associated with the rest of the law are more problematic than the temporary ban associated with the domestic violence restraining order. Now, the court doesn't explicitly say that, but they do go out of their way to say, well, this part of the reason this is okay, or at least is that we're not striking it down, is because it's temporary. And so this kind of clears up. This is a way to address all of these legal fights that you alluded to, right? DOJ can and already has actually pointed to this process and said, you don't need to sue for your rights back because we are going. This is what they did in the Range case. They said, we're not appealing this, but also we have. They explained to Congress that essentially they didn't think that the Range case was, the court was correct there, but also that the Supreme Court doesn't need to get involved because they have this rights restoration process instead, or they're going to. And for a while now, it's been they're promising to have a rights restoration process, and up to this point, it's just been an ad hoc one for 10 people. Now they dropped this rule that's pretty comprehensive, and they actually, in the rule itself, expect that 1 million people are going to go through this in the first year. So have a much more legitimate, I think, argument now in court that some of these cases probably should go through this process first before they seek judicial review. So it's a way of I think of effectively sidestepping a lot of these cases, or also just like solving the legal issue before it crops up as a lawsuit, right? Because if you restore someone's rights, then they can't sue you to say that you're unconstitutionally infringing on their Second Amendment rights. So in that sense, I think it helps them avoid the kind of cases that we've been seeing since Bruin was handed down in 2022. And that's honestly one of it's interesting. We've talked about this from the beginning. Like, is that strategically for the gun rights movement, you wonder what the better course is, because somebody like Range, who lied on a food stamp application in the 90s, lied about his income to get food stamps. Super sympathetic plaintiff there. Had his gun rights completely abridged for lying on a food stamp application for the rest of his life, effectively. And he was one step away from the Supreme Court, but the DOJ decided, they didn't appeal his win at the Third Circuit, and they're pointing to this process as the solution instead of potentially a Supreme Court precedent, which would be, frankly, a more durable outcome for gun rights advocates. If they did in fact win on a case like Range at the Supreme Court, I think that sets a more durable precedent. However, if this process unfolds the way that DOJ is saying it will in this rule, it addresses much of the problem. Now, it's something that can always be undone in the future. Although, honestly, you wonder if it would be undone if like we just talked about. A lot of it is fairly uncontroversial. Maybe the domestic violence misdemeanor aspect might be more controversial, because a lot of people are opposed to domestic abusers owning guns, even perhaps 10 years after their conviction is done. Now there's some people who you may get some criticism the other way around, that it doesn't go far enough. Some people think in the gun rights community that if you've served your time in jail, if you're allowed back out in society, then you should be allowed to own a gun, regardless of whatever your previous conviction had been. The idea being that if you're too dangerous to own a gun, you're too dangerous to be in society, and you should be in jail or whatever, right? So that's an argument you will sometimes hear from at least some gun rights activists. But I think the bulk of people will be more or less okay with most of what they've gotten here. So it could easily survive into the next administration. And again, it solves that legal issue of, well, I think the Supreme Court is much more skeptical of lifetime bans for especially nonviolent felonies. And if you have a rights restoration process like this, it's one less reason for the Supreme Court to get involved, whether it's a Democratic or Republican administration at the helm of DOJ. So, but anyway, we got the first details. Pretty interesting. Jake breaks it all down in his members piece for anybody who wants to read more in depth on exactly what the details are here. But pretty big development that we finally saw DOJ follow through on this rule, and now has everything in black and white on digital paper. I suppose you could print it out in ink, I guess. But and so now we wait for the reaction, for the comment period, and see if DOJ is going to adjust any of this in response to the comments before we get to the final rule going into effect. But that's our first story. Next story we've got here was actually written by you, Ben. This is DOJ drops appeal in pistol brace ban case. Can you give us a little bit of background on what happened here?
Yes. So during the Biden administration, the ATF implemented a rule that basically pistol braced weapons were short barreled rifles, right? Because under their logic, a rifle is a weapon that's intended to be shouldered. And they were thinking that if you put a pistol brace on a pistol, then it could be intended to be shouldered, essentially. And,
the NFA says that's the definition of rifle under the National Firearms Act, right?
Yes,
and they're saying essentially that people who use pistol braces, which are designed to be strapped to somebody's forearm rather than pressed against the shoulder, but ATF and the Biden administration essentially said, we think you're just using that as a workaround to the National Firearms Act, so you don't have to register these guns and pay the tax stamp associated with the NFA. So we think this whole pistol brace thing is a workaround, and we're going to reclassify all of them as though they are short barrel rifles and treat them that way, right?
Yeah. So yeah, pistol braces were introduced around 2012 and presented for the ATF to decide if this was legal and did not turn a pistol into an SBR. And they changed their mind about 10 years later. And
Yeah, initially they said these aren't NFA items. Then they kind of waffled around for a while. You got some different determinations, and there was a whole period where they were claiming, well, they're not NFA items when they're sold, but if you press one against your shoulder, you've redesigned it, and now it has become a short-barreled rifle. Yes, it was kind of a wild mess at the ATF for about 10 years there on what these devices were. But in that period, millions of these got sold, right?
Yeah. And so, of course, it was challenged in court. It lost in the Fifth and the Eighth Circuit. And in a case that was titled Mock versus Garland, now Mock versus Bondi, of course, because the Attorney General has changed since the Trump administration came in. The DOJ finally has decided to withdraw their appeal. They don't want to challenge this anymore after they had lost and the rule was vacated.
Yes. Yeah. So significant movement, right? Because basically it means the legal fight over this rule is over. Mm-hmm. The legal fight over it is over. But yeah, it means effectively the rule is done now. They accomplished that through legal maneuvering rather than rulemaking. So that was a bit of a twist. They promised, the President Trump had promised to roll back everything that President Biden did on guns. And he promised to do it in the first day or week of his administration, which didn't happen on that timeline. But here's an example of one of those rules being effectively rolled back. And so sort of fulfilling that promise, but doing it in a way that, initially they had talked about, they were supposed to review this rule, the ATF, and with the implication that they were going to start rulemaking to undo it through the same process that it was put in place, right? When federal rulemaking is basically just agencies issuing their interpretation of how federal law is supposed to be enforced. And the Biden administration used the ATF to put together like 4 different rules, one of which has been upheld by the Supreme Court, the frames and receivers rule or ghost gun kit ban. But the other ones have been languishing in lower courts, including this pistol brace rule, which is probably the most significant of the Biden era rules because it affects the most people. As I mentioned, millions of people bought these pistol braced guns in that period where the ATF was kind of flip-flopping around on their legality, but certainly didn't try to arrest people for the ownership of pistol braces or pistol braced guns with barrels less than 16 inches long. And so, that this rule, when it went into effect and basically said, unless you register these braced guns as SBRs or SBSs in some cases, short barrel shotguns, then you are in possession of an unregistered NFA item, which is a federal felony. But most people did not comply with that. Most people did not register there, at least as far as nobody knows exactly how many of these are out there. There's pretty wide variety of estimates. The ATF estimated itself between 3 and 7 million, I believe. And then the Congressional Review Service, which does Congressional Research Service, which does reports for Congress, they estimated there were 10 to 40 million, which seems super high. But either way, only about 250,000 were ever registered during this amnesty period, because the ATF, the way they've done these rules, this is similar to the bump stock ban, the way the ATF did that one under the first Trump administration, where they kind of claimed that these things were always illegal and they were just not enforcing that aspect of the law. And so when this rule was put out, ATF granted like a grace period where they also eliminated the tax or the for on these items and said you can register these without paying the tax, but you have until this period of time, and then anyone with one after that point will be considered to have a unregistered NFA item, which again would be a federal felony. It could be 10 years in jail is the maximum for that. But despite all that, the vast majority of people didn't, or the vast majority of these guns weren't registered at the very least. And so, but part of that too is they immediately, as you mentioned, ran into legal problems. Were enjoined in the Fifth and Eighth Circuits, and those rulings encapsulated all the members of like the gun rights groups that had sued over this: Firearms Policy Center or Firearms Policy Coalition, the Second Amendment Foundation, Gun Owners of America, National Rifle. They all got their members covered by these rulings eventually. And so there really wasn't any enforcement action on the part of the ATF during this period. And now, effectively, DOJ deciding not to appeal that Fifth Circuit ruling sure seems like the rule is essentially dead at this point. With it, whether it's interesting to me. I don't know how that plays out. If a Democrat retakes the White House in 2028. All these things, rulemaking and deciding not to pursue certain legal courses, probably reversible, I guess, down the line. But it seems to me like reversing the rule itself may have been more permanent action here. It would take about a year to go through that whole process. But so they chose to do this instead, it seems. Maybe they will still go with rulemaking at some point, but at least for now, the bottom line is people don't need to worry about the pistol brace ban, coming back into effect or being enforced because they've agreed to drop this appeal, and the ruling will stand now.
But even if a Democrat became president and they wanted to bring back this rule, it would probably come back in a different form. To try to fix some of its constitutional issues. It would probably be a lot more specified, because one of the critiques of the rule in court was that it was very vague and it was hard for the average person to tell when a pistol braced weapon becomes an SBR.
Yeah, and that was on purpose, right? Because the ATF was essentially, with their final rule, they had a preliminary rule that had like a whole point system and guide sheet where you could, which wasn't perfect by any means, but it was designed to be like you could try to figure out if your gun was a short barrel rifle under the ATF's understanding this rule. And they just gave up on that and went with some more vague subjective standards in the end, which the courts didn't like. But effectively they were saying, oh, there may be some braced guns that aren't SBRs, but it sure, by the language, sure seemed like it was pretty much all of them. But anyway, that ends the saga. That, at least for now. I'm sure it doesn't end the fight forever over short barrel rifles and pistol braces and all this NFA stuff, as we've seen, has been at the top of mind lately in the gun policy realm. But we have our next story also comes from you, which is the federal judge greenlighting the concealed carry permit delay lawsuit against Los Angeles County, the sheriff's department there. So this is an interesting update here. We won't spend a ton of time on it, but basically the Los Angeles Sheriff's County Sheriff's Department and the sheriff there, Luna, they'd had a preliminary injunction issued against them already over this lawsuit that deals with the failure to issue out-of-state resident permits or accept out-of-state resident applications altogether, and then also some of the years-long delays in actually issuing permits to residents after Yeah, this all fallout from the Bruin decision in 2022, and California, along with a number of other states, had to change their law to make it what's called shall issue, which means if you go through the permitting process and you pass the background check, that they shall issue you a permit. They have to. Whereas before it was more of a subjective process called may issue. Like you go through all that stuff and they may issue you a permit, but they don't have to. So now that they're under shall issue, you've seen some, I would say, local resistance to this process, even though the state law requires that localities issue these permits within 120 days of receiving the application. What you've seen in some places, like Los Angeles County, apparently, is that they will just refuse to accept the application until potentially years down the line, and they'll claim that they're in compliance with the law because they processed the application within 120 days. They just don't accept it for a year and a half beforehand, which is not a new thing. You've saw this back in Philadelphia, did this during the COVID pandemic and gotten similar legal trouble for this. But anyway, these plaintiffs in this case, which include like Gun Owners of America and I think Second Amendment Foundation's involved in this one as well, they had secured that preliminary injunction, but then some of the individual plaintiffs, the Los Angeles, started giving them their permits, right? It was, for some of these people, it took 2 years to actually get the permit, but they did get the permit after that injunction and after the order that the judge, handed down on how the process was going to work. And so then the sheriff's department said, well, hey, these people don't have a case anymore. There's no harm anymore because they got their permits. So we should be able to dismiss their claims, right? And what did the court rule in response to that?
Yeah, so they said because the plaintiffs are still seeking nominal damages and just because they had already received their permits, does not mean that they don't have a case. They can still sue for nominal damages in this case. And then also they challenged the standing on a lot of other things too in this motion to dismiss. They challenged the standing of the gun rights groups, saying that they needed to do this individual assessment of their members to show that they had standing. But the court disagreed because it's actually not too difficult for a group to have standing in a case. They don't have to really prove to the same extent as an individual that they have standing.
Yeah, they don't have to go through and find, write down every member who has been, harmed by the process. They can sue as an organization and claim that their membership would be getting these permits otherwise, and that's enough to have standing in the case essentially. And also, the sheriff and county the department also tried to claim 11th Amendment immunity from these sorts of cases, and the court denied that as well. So they lost pretty much across the board. I think the only thing you saw,
they technically won on one issue,
right?
It was because they said the plaintiffs are not allowed to facially challenge every permit denial, because of course there are some instances where denying a permit is constitutional, and for a facial challenge to be upheld, they have to prove that there is no instance where the law is implemented that is constitutional. And of course, there are constitutional instances of denying permits. So what the court said, they granted that part of the motion to dismiss. However, the plaintiffs had clarified, that's not what we're challenging here. We're challenging the delays. The delays are unconstitutional.
Yeah, so pretty successful ruling for the gun rights plaintiffs in this case, and a near total loss for the Los Angeles defendants. So that case is going to move forward to the merits stage now, I believe, because we've been on, and the gun rights groups have a very good chance of winning, because that's the whole idea behind a preliminary injunction. Is you only get those if the court already believes you have a high likelihood of winning on the merits. So we will continue to watch that case, but it was a good development for the groups in that case, and for anyone who's hoping to get a non-resident California concealed carry license as well. But we got a couple of links from outside of the Reload as well, including one on a new lawsuit in New Jersey against New Jersey's silencer ban that's filed by a number of gun rights groups there, a coalition as well that includes the Second Amendment Foundation again, the American Suppressor Association, the National Rifle Association, and the Association of New Jersey Rifle and Pistol Clubs, which is an NRA state affiliate. And so they are trying to have New Jersey's total ban on the ownership and possession of silencers struck down. And the interesting thing about this case, I think, one of the most interesting bits of it, is that they're pointing to this filing that the Department of Justice made in a Fifth Circuit case against the National Firearms Act, which we talked about, I think, a week or so ago on the show, because the DOJ, with the new administration coming in, they've changed their position on the National Firearms Act and silencers to a certain degree, right? They filed this new brief in a case that was already decided out of the Fifth Circuit, a case where a panel of the Fifth Circuit upheld the National Firearms Act restrictions on silencers and its registration requirements and its tax. And the DOJ there changed its position from just being wholly in agreement with the court that silencers aren't protected and therefore the Second Amendment challenge doesn't work. They changed their position to say that actually silencers do enjoy some protections under the Second Amendment, that they aren't arms necessarily, but they are protected by the Second Amendment. The Second Amendment umbrella, the penumbra of the Second Amendment protects silencers to some degree because they are useful for carrying out the right of keeping and bearing arms, because they help you protect your hearing when you're shooting, and they make your shooting more accurate. This is sort of the argument that DOJ had made in that Fifth Circuit case, and is similar in nature to how the Second Amendment protects, to some degree at least, commercial sales of firearms, even though that's not part of the literal keeping and bearing of arms, or the practice of using your firearms. So there's some Second Amendment protections for shooting ranges, for instance, that there have been federal courts that have held that, and specifically in Ezell in Chicago, that struck down a Chicago restriction on that made it so there couldn't be shooting ranges in the city. And so it's kind of, DOJ is now arguing that the silencers are included in this broader protection of the Second Amendment. However, of course, they went on to say that the National Firearms Act doesn't actually violate the Second Amendment because it's a tax and registration scheme instead of an outright ban, and so the silencers get some Second Amendment protections, but not the same level as just owning guns or carrying guns. Is the DOJ position here. And we talked about how the implication from that doesn't really help anyone who wants to see the NFA struck down under the Second Amendment, right? Because the DOJ is still saying it's constitutional, but it could help against some of these outright bans that we've seen in the states. And that's what we're seeing here, right? That's exactly what these gun rights groups are arguing in New Jersey, right?
Mm-hmm. Yeah. So in that Fifth Circuit case, I believe it was McCoy versus ATF is the name of it. So the case was actually withdrawn after the DOJ sent in their brief. And
yeah, the order was
withdrawn.
Case,
mm-hmm.
They haven't issued a new one yet, though, so we don't know exactly what the court's going to do there.
Yeah. It's still a mystery why they withdrew it. All they said was that they had withdrawn it. But essentially in their original ruling, when they applied the test that was created in the Supreme Court's Bruin case, the first step of it is to analyze if the conduct fits directly under the scope of the Second Amendment just at face value. And the first question that they asked was, okay, is a suppressor an arm? And they ruled that it isn't, right? And then the DOJ, after the Trump administration came in, said, hey, that's not necessarily the legal framework we need to be looking at this through. As you've explained, there's a lot of other things other than just arms that are a part of the right to bear arms. And so they need to change the whole legal framework around it. And that is exactly what they're trying to do in this new New Jersey case. they're applying the DOJ's new brief and saying, hey, suppressors are still protected. And some regulations on them, like the NFA, are constitutional just because they are not as stringent, but an outright ban would definitely be a Second Amendment violation. That's what they're arguing in the New Jersey case.
Yeah. So it's interesting to see that kind of what we theorized coming to life before our eyes here, right? We thought, hey, this briefing, it doesn't do what a lot of internet commentators, I think, have said it does. That the DOJ is not arguing that silencers are arms. They're arguing that despite the fact that they aren't arms, they're still protected in some way by the Second Amendment, and also they're not saying that the NFA is unconstitutional. They're saying the opposite. They're saying it is constitutional because they kind of do an interest balancing argument there, which is interesting because that's like exactly what the Supreme Court has rejected in Bruin, but for Second Amendment stuff. But that's what they end up doing. They say, well, it's a lesser burden, right, on a lesser protected aspect of your Second Amendment rights. But in the end, we thought, hey, this could be helpful for people who want to challenge these outright bans that we do see in some states. You know, the federal law, the NFA, is not an outright ban. It's a registration and tax scheme. And so it's, potentially less problematic constitutionally under the Supreme Court's precedents here. But there are outright bans that states have. There are states that have outright bans, including New Jersey. And so if the court sides with DOJ here, that could be a good precedent for gun rights activists looking to get rid of those outright bans. Now, they've gone ahead and not waited for the court to give them to side with this idea. They're just kind of citing the DOJ saying it. And I do wonder how much, like, I feel like a Fifth Circuit ruling would have more actual weight in a case like this than just the DOJ's brief. But it's still something, and perhaps the Fifth Circuit will come down on the side of what the DOJ was arguing here, and then they'll get even more backup for this lawsuit. But they're not waiting. These gun rights groups aren't waiting for the Fifth Circuit to reissue their opinion. They're just going ahead with and using the brief itself, and it'll be interesting to see how. Obviously, even a ruling out of the Fifth Circuit isn't going to have an impact in what's New Jersey, the Third Circuit or the Second Circuit. The circuits are always harder. Off the top of my head, I think it's third. Yeah, it's with Pennsylvania. I think Pennsylvania, Delaware, and Jersey, the tri-state. There's probably more, but either way, Third Circuit. Obviously, a Fifth Circuit ruling is not binding on the Third Circuit, but it does help. If you can get, other federal courts on your side in a case. And it does help, I think, if you can get DOJ on your side, at least some of the time. Right. So we'll see how that all plays out. We also have a little story here from Jeff Asher. I just wanted to touch on real briefly as an update to, we had Jeff on the show a couple months back talking about the crime trends, and they're continuing in the way that he predicted, which is that we're seeing a huge decline in crime, and we're continuing to see a huge decline in crime. I'll just quote from the beginning of his piece. Crime almost certainly fell considerably in the United States in the first 6 months of 2025. The decline in crime that began in 2023 and picked up steam in 2024 has accelerated even faster so far in 2025. Both violent and property crime likely fell, with large drops in both murder and motor vehicle theft leading the way. So we're halfway through the year, over halfway through the year now, here in July. And the trend we saw at the beginning of the year that Jeff has pointed out has continued as he thought it would. And we are actually on pace to see near record lows in the murder rate by the end of 2025, according to, and Jeff, people should go back and listen to the episodes he's been on, but and perhaps we'll have to have him on again real soon here, but he has predicted, or he collects his own crime data from most of the major city police departments that release data publicly, and that there's enough of them that cover enough of the population that you can get a very good idea of what the final numbers are going to be, even though the FBI and CDC don't release their, especially the FBI doesn't release their data until like a year and a half, or yeah, they don't release until significantly later. I think we don't have 2024's numbers from the FBI, the final numbers yet, here in to halfway through 2025. So, it's good to, obviously you want to confirm with the FBI data, but generally speaking, Jeff's methods are super reliable. So positive news, it went up. I think there was the fastest rate of increase in 2020 and 2021. And then began falling at an incredibly fast rate as well in 2023 through 2024. And now that positive trend has continued through at least the first half of 2025. And that's a remarkable thing that doesn't get enough attention, I think, generally speaking. And people generally have a fairly bad idea of what the crime rate actually is most of the time. And I think that's been true for a very long time. The crime rate fell significantly through the 2000s, through the early 2010s, and people still thought that the crime rate was really bad. And I think that's still happening now. So it's good to check in on that and understand what's really happening.
Yeah, I think it'll be interesting to follow up on this too, because the violent crime rate in the United States tends to peak around between July and August, right? So once we enter the fall and we can see the numbers for the summer, it'll be interesting to see if the decline still continued over the summer.
Yeah, that's what Jeff expects, and maybe we'll have to have him on to give us some more detail on this and insight. But good news, generally speaking, here that the decline in murder and violent crime and even property crime has continued through the first half of this year. But yeah, just to close it up here, let's talk a little bit more about you and NJC and your experience so far. What have you really enjoyed about this program that you're in, this reporting program? What's been your favorite part?
Probably getting to understand these legal arguments. I spent a lot of the first week working for you just reading up on these Supreme Court cases that I didn't know anything about before, and getting to see myself gain all this knowledge in this particular legal field, which has a very few number of Supreme Court cases, but also a very broad interpretation of them. And getting to read all these circuit court cases to see how they've applied these rulings, such as the Bruin ruling, of course.
Yeah,
it's my legal expertise.
It's a really interesting area of law to be focused on right now, because they're kind of birthing a new standard, right? That Bruin creates a new test for the Second Amendment cases, and that just happened 3 years ago at this point, and they really haven't. So it's created a lot of diversity of opinion in the lower courts about the best way to apply that standard, certainly, and the Supreme Court itself hasn't weighed in a ton. But I mean, you're really an aspect of federal case law here that's practically brand new. Like the First Amendment, there's been thousands of First Amendment cases, right, that date back to the founding of the country, right? Second Amendment just hasn't been much litigation on it at the federal level. It really, Miller is technically the starting point that you would look at for where this court's current view of the Second Amendment sort of began, or at least where they themselves had pointed to in the landmark case in Heller, which kind of started this whole Second Amendment jurisprudence that the court now relies on.
That was in the 1930s.
Yeah, Miller
was long ago.
But even still, 1930s is very late for Bill of Rights litigation, right? And you really only have like 6 cases at the Supreme Court to look at, so you can kind of get caught up on a lot of at least what the Supreme Court has said about the Second Amendment pretty quickly, and then there's possibility for evolving that significantly with each new case that the court takes, because there's unlike a new First Amendment case, they're getting into some extreme detail about First Amendment protections, right? Because they've already litigated it 1,000 different ways, whereas the Second Amendment, you're still getting to core questions, I think, that haven't been settled, right? We just talked about like lifetime prohibitions. Is that constitutional under the Second Amendment or not? we don't have an answer from the Supreme Court. We have lower courts and how they've adjudicated it, and or even just who can be prohibited. They've only really answered that for the domestic violence restraining order, people subject to that. Now, they implied some other things in that ruling, including this idea of dangerousness being important, but they haven't flushed any of that out yet.
Yeah. There are a lot of cases about administrative overreach as well.
Mm-hmm.
It's not all just Second Amendment cases that go into firearm law.
Right.
Because we have like the ghost gun case, bump stock case, and now, of course, this pistol brace case.
They've done more on that stuff than they have on the actual core Second Amendment
probably
question. So, but it's an interesting time to be focused on it for sure, I think. And yeah, what did you think about the class that we did a couple, what is it, 2 weeks ago now for NJC, where I go and do a range day and try to teach you guys some basics of the trade, I guess, as far as reporting on guns goes. Did you find that helpful or fun?
Yeah, that was very helpful. They did a suppressor demonstration for us to help some of the students understand that suppressors don't actually silence the weapon, because they're often called silencers. A lot of the students, I don't think they had fired a gun before. I had fired, of course, before in my life, but I think it really helped them a lot. And getting to try out all those different weapons was a lot of fun too.
Yeah, and that's the goal, is to try and make sure that people are learning some stuff. Especially, you have a little bit of a leg up because you've been doing the firearms reporting here at the Reload for months to that point. But even still, I'm sure that we touched on some stuff that hadn't come up directly in your reporting here for us. And the goal there is always to try and inform people, just to give them a better understanding, especially if they might end up, having to write something on guns, and you don't want to make a fool of yourself when you do that, which happens far too often in this industry, I think. And then on top of that, to try and give you some practical experience with actual firearms, so you have some understanding of how they work, or what a silencer actually does, and why the name is more of a marketing, term than a description of reality. And why a lot of people in the gun world prefer to call them suppressors instead of silencers. But yeah, I think it's good to get that hands-on experience just manipulating firearms in a very safe environment, of course, surrounded by range safety officers who are overwatching everybody handling firearms. But and I think this year is probably the best one we've had, because it's the largest class and it went smoothly, and I was very happy with it. I'm glad to hear that you enjoyed it as well. But we will have you back next week to be the co-host, as Jake will be on his honeymoon by that point. So we're very excited for Jake and his fiance to get to the actual wedding. We've talked a lot about the planning. I'm still in the planning aspect of my wedding. So Jake will be first through the gate there and be on the other end of all the stress, and just get to enjoy himself hopefully once his wedding happens this weekend, and then he's on his honeymoon. So we're happy for him, and we're happy to have you here in the meantime to try out some of this podcasting stuff as well, in addition to the writing.
Thanks for having me on.
Yeah, absolutely. And we'll have you back next week as well. And that's all we've got for you guys. You head over to reload.com if you want to sign up for our free weekly newsletter that keeps you up to date with what's going on with guns in America from a sober, serious perspective. And you can, of course, buy a membership if you want to support the kind of reporting we do here at The Reload. That is how we operate as an independent publication, and how we're able to bring you the news that we do. That's all we've got. We will see you guys again real soon.